Welcome back to the Dispute.a podcast. I'm Paul, and this is episode 5. This is the episode I most wanted to get right, because Article 11 is the single most important provision for off-land property disputes in Dubai, and most people in those disputes have never read it. Let me start by clearing up a confusion that's common, even among people who should know better. Which Article 11? There is more than one Article 11 that comes up in Dubai. Real estate conversations, and they are not the same. There is law, no. 8 of 2007, the Escrow Accounts Law. It has an Article 11, and that article is about escrow account operation, the account being held in the project's name, dedicated to that project, protected from the developer's creditors. Important law, not the one that governs termination disputes. The provision that governs what happens when an off-plan sale agreement is terminated is Article 11 of Law No. 19 of 2017, Law No. 19 of 2017, amended Law No. 13 of 2008, which regulates the interim real property register in Dubai, the register of off-plan units before they're completed and formally titled. When people in the dispute world say Article 11, this is almost always the one they mean, even if they cite it loosely. So for this episode, Article 11 means Article 11 of Law No. 19 of 2017. Why this article was amended? Article 11 didn't appear from nothing. The 2017 amendment exists because the earlier version of the provision had been interpreted in divergent ways by different courts. Disputes over off-plan sale agreements, particularly disputes about a developer's rights to terminate when a buyer was in breach, were producing inconsistent outcomes. Different courts read the same provision differently. The methods of implementation diverged. The result was uncertainty. A buyer or a developer couldn't predict with confidence what would happen when an off-plan agreement broke down. The 2017 amendment was written to fix that. It was an attempt to make Article 11 clearly understood, so that its interpretation didn't keep conflicting in ways that hurt the market. Understanding that history helps, because it tells you what the article is for. It's there to make the consequences of termination predictable. What Article 11 governs? Article 11 governs what happens when an off-plan sale agreement is terminated because the buyer is in breach of their contractual obligations, most commonly failure to keep up with the payment schedule. The core mechanism it establishes is this: when a buyer is in breach, the developer has a right to terminate the agreement and to retain a defined percentage of what the buyer has paid. The exact percentage is tiered, and it depends on how far the further the project has progressed, the more the developer is permitted to retain. A project that's substantially built represents substantial committed developer investment, and the retention reflects that. Project barely off the ground permits a smaller retention, as progressed, measured by construction completion at the time of termination. I'm deliberately not going to recite specific percentages in this episode, and I want to be honest about why. The tiers are precise, that set by the legislation, and they interact with the project's registered completion status and with subsequent regulatory developments. The percentage that applies to a specific dispute is something that has to be confirmed against the current legislation and the specific projects. Cite, US not quoted from memory in a podcast. What matters for understanding is the structure, a tiered retention, scale to construction progress. The part that surprises people. No court ruling required. Here's the feature of Article 11 that surprises buyers most, and that they most need to understand. The developer's right to deduct the prescribed percentage does not require a court ruling. It is granted by the law itself. The developer may exercise this right at their own will, as a legitimate means of execution against a buyer who is in breach. Read that again, because it inverts what most buyers assume. Most buyers assume that if there's a dispute about their money, nothing happens to their money until a court decides. They assume the default state is that the money sits frozen, protected, until a judge rules. Article 11 does not work that way. The developer's retention right is self-executing. The developer doesn't have to sue the buyer to establish the right to retain. The law has already established it. The buyer who wants to challenge the retention is the one who has to take action, not the developer who's exercising it. This single feature reshapes the negotiating dynamic entirely. The buyer is not sitting on protected funds waiting for a ruling. The buyer is in a position where the law has handed the developer a self-executing remedy, and the buyer's task is to work within or against that through negotiation or through challenge, rather than to simply wait. What the developer owes back and when. Article 11 doesn't only define what the developer can keep, it also defines what the developer must return and the timing. Where the agreement is terminated, the developer must refund any amounts paid by the buyer in excess of the percentage the law allows them to retain. And there's a defined time frame for that refund. The developer must return the excess within 1 year from the termination of the agreement, or within 60 days from the date the unit is resold to another purchaser, whichever comes first. That whichever comes first matters. If the developer resells the unit quickly, the 60-day clock from resale can be much faster than the 1-year clock from termination. The buyer's refund timing is therefore partly tied to the developer's resale activity. So the full shape of Article 11 is the developer can terminate a defaulting buyer's agreement, retain a tiered percentage scale to construction progress without needing a court ruling, and must refund the excess within 1 year of termination or 60 days of resale, whichever is earlier. What this means for a buyer in difficulty, if you're a buyer who has fallen behind or expects to fall behind on an off-plan payment schedule, Article 11 is the provision that defines your downside. Understanding it changes what you do. It tells you that walking away silently is the worst option. If you simply stop paying, the developer can exercise the Article 11 retention against you, and you've surrendered any opportunity to shape the outcome. It tells you that engaging early, before you're in clear breach, is far better than engaging late. A buyer who comes to the developer before defaulting with a restructuring proposal or a managed exit proposal is negotiating from a different position than a buyer who has already triggered the developer's Article 11 rights. It tells you that the retention percentage, while set by law, exists in a negotiation context. The developer has the legal right to the tiered retention, but developers also have incentives. A unit they can resell easily, a buyer who cooperates with an orderly exit, a dispute they'd rather not carry on their books. Those incentives sometimes create room to negotiate the practical outcome below the maximum retention the law would permit. Not always, but the room exists often enough to be worth working for, and it tells you that the refund timing is something to build into your planning. Even in the better outcomes, the excess refund can take up to a year or 60 days from resale. What this means for understanding developer behavior. Article 11 also explains developer behavior that otherwise looks aggressive. When a developer moves quickly to terminate a defaulting buyer's agreement, they're not necessarily being unreasonable, they're exercising a self-executing right the law has given them. When a developer is unwilling to simply hand back a defaulting buyer's full payment, they're not stonewalling, they're standing on a statutory retention right. Understanding this doesn't make the buyer's position more comfortable, but it makes it accurate. And an accurate read of the counterparty's position is the foundation of any sensible pre-legal strategy. Article 11 hands the developer a self-executing retention right that needs no court ruling. The buyer who understands this stops waiting for protection that isn't coming and starts working the position that actually exists. What to take from this episode? The Article 11 that governs off-plan termination is Article 11 of Law No. 19 of 2017, amending Law No. 13 of 2008, not the Article 11 of the 2007 escrow law. It was amended in 2017 specifically to make the consequences of off-plan termination predictable after years of divergent court interpretations. Its core mechanism: when a buyer is in breach, the developer can terminate and retain a tiered percentage of what was paid. Scale to construction progress. The specific percentage must be confirmed against current legislation and the project's status, not quoted from memory. The feature that surprises buyers most: the developer's retention right does not require a court ruling. It is self-executing. The buyer who wants to challenge it is the one who must act. The developer must refund the excess above the permitted retention within 1 year of termination or 60 days of resale, whichever is earlier. For a buyer in difficulty, the lesson is to engage early, never to walk away silently, and to understand that the retention, though set by law, exists within a negotiation context where developer incentives sometimes create room. In the next episode, we look more broadly at off-plan disputes and the developer's position. Thanks for listening. The full transcript is at transcript.a. For pre-legal dispute support, dispute.a is where that work is done.